Welcome, my name is B, and I'm going to give you a brief overview as to what you can do if you're unhappy with the healthcare you have received. Under the Australian Charter of Healthcare Rights produced by the Australian Commission on Safety and Quality in Healthcare, each person is guaranteed 7 rights, namely access to safe healthcare, respect, communication, participation in decision-making, privacy, and comment, no matter where you are in Australia. The vast majority of healthcare professionals competently carry out their work to the best of their abilities. And just because you have sustained an unexpected outcome does not mean there has been negligence. What you decide to do next will depend on both the facts and what you're looking for. In the first instance, if you are looking for explanations, clarifications, apologies, or remedial treatment, or you have concerns about the competency or behavior of the healthcare staff, or systems issues of the healthcare provider, and you want to prevent something like this from happening again, you should apply to the healthcare provider himself or the health ombudsman. They will seek a conciliation between the parties. They can provide further contact and explanation, a second opinion, remedial treatment, assistance with obtaining social services and home services, and could offer to change systems or procedures so that a similar incident like this will not happen again. And if there are any questions concerning the competency of the health professional, the health ombudsman will then refer the case on to AHPRA, who will investigate as to whether any medical negligence has occurred and could result in caution, a condition, or even deregistration of the health professional. If there has been negligence for which you have suffered an injury, then you will need to pursue a claim under the tort of medical negligence. So who can sue? A person injured or someone on his behalf. If the person has died as a result of the injury, the cause of action survives to benefit his estate. In the case of wrongful death, the personal representative or family members can sue. There are 2 areas of medical negligence. Firstly, diagnosis, management, or treatment. In that case, the health professional has breached his duty of care by acting or failing to act in a manner widely accepted by his peers, and this breach has caused an injury. Secondly, it could be a failure to warn of risk by not giving sufficient information that a reasonable person would require in the circumstances to make an informed decision. In Queensland, these actions are mainly covered under the Civil Liability Act and Personal Injury Proceedings Act. So what can I sue for? In general, one can sue for damages to cover past, present, and future medical expenses, loss of income, home care costs, and pain and suffering. However, time is of the essence. Although a suit for personal injury can be filed within 3 years, notice needs to be served on the defendant between 9 months of the injury or development of symptoms, or within 1 month of instructing a lawyer. You should seek legal advice without delay, as the process is long and complicated, with many defined steps that have to be taken. You will first need to assemble all the medical records you have and keep an accurate account of timeline of events and the names of all the professionals you have come into contact with. Medical examinations and tests may have to be carried out to assess your current state of health. Experts will need to be engaged to assess the merits of your case. After document exchange and interrogatories, a compulsory conference will have to be held, during which a mandatory offer to settle must be made. While the vast majority of cases settle out of court. So, if you're not happy with the healthcare you receive, you should first make a complaint to clarify the situation, obtain your medical records, and keep a good account of ongoing events. Finally, due to the short time limit, you must act without delay. Thank you.